I'm not your bro. I'm not your man, and I'm not to be interrupted when I'm speaking. Just because you're unsatisfied with the way that I ruled, then that's not my problem.
Hey guys, welcome to today's video. Today we head into Judge Perkins' courtroom to deal with another sovereign citizen who thinks he knows more about the law than every practicing lawyer and sitting judge in America. So let's begin.
City of Detroit versus Christopher Perry Lewis, case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Today is the date and time set for a ring on the bench warrant. I'm going to enter not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email?
Chris, CHRISLEWIE, Midtown, that's MIDTOWN @
Chris CHRISL, right?
Yes, EWIE.
I have it.
So this self-proclaimed legal genius cannot even figure out how to send an email properly. That honestly makes sense to me.
Okay, I'm resending it at the moment.
I'm gonna put my email address in the chat and put my email so you'll have it, and send that to me, and we will have an opportunity to read that. I'll wait to confirm that you send it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I actually just sent it to the prosecutor as well. Daya Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her an attachment. If she could send me a confirmation that she received it.
Get it to her email address. So, Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File. Of that motion, those motions that it passed. All right. I'm gonna wait on that. Once I confirm that you gave me that, I will recall the case.
After many attempts and what felt like half a bottle of glue consumed, he finally managed to send his email to Judge Perkins. But it only took Judge Perkins reading a couple of lines to dismiss it. That really upset the sovereign citizen.
Let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case if you get a chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion because
I would just appreciate a written excuse. Can I get a written articulation?
I'm not give it to you in writing. what I
Are we
will
on
do,
record? Are we on record?
we're on record.
Okay. This court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you're denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm
I'm
denying.
saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Well, you got a real judge and not an Article 1 judge like you said, but we will get to that in a minute. What you do not get is a change of venue free card that allows you to move your case from one court to another just because you did not get your way.
Okay, I'm denying a motion to dismiss, okay? I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion so I can take that to the tenor, okay?
Well, you can insist all you want to.
Okay, I appreciate that. But I'm telling you, you're telling me today why you're not going to look into it or give me a hearing as so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that. So I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming.
If it had truly been overwhelming, it would have been dismissed. Your motion was denied because you made the exact same sovereign citizen claims as always. It only takes a real judge like Judge Perkins a quick glance to realize there is no legal basis for any of.
So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest. You only here to make money, man. You know what I'm saying? It ain't no crime.
Ain't no
victim or no loss, bro.
Listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody.
Oh, he has talked to plenty of you, but none of you have been able to make a legally convincing argument that has any legal merit whatsoever. So unless you went out and purchased some super secret sovereign CI and court information that none of the other knots have ever found, then none of it is going to be new. Today you will be providing nothing more than unintentional deprecation for all of us to laugh at.
I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more from
cool. It's cool.
You made your
I appreciate
you made your record.
This is due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're not prepared to present a case. I'm telling you. They're not prepared to present an inter-party. So what are we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever reason. Wait a minute, let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
Your peers, and you can argue it that way. Okay, a jury of his peers. You mean a bunch of third-year third-graders?
I appreciate that, but I was still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not I'm not even going to hold you to that, but in paragraph 2. Moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages/losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand.
It is not correct, Judge Perkins. Article 1 judges are typically federal judges and derive their jurisdiction from Article 1 of the United States Constitution. Judge Perkins, on the other hand, is a state judge and derives his jurisdictional powers from the Michigan State Constitution, which gets its authority from the 10th Amendment of the United States Constitution.
Indicating a clear conflict of interest, I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrard v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party. Corpus delicti, there can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion, all right? And you can get a copy of that record on what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The reporter is not going to respond to your voice message. The court reporter is going to respond to you
The
coming
36th
down.
district told me to call her today. that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels,
think
and
you're
y'all
talking about-
doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is a distinct.
Yeah, I was told to call the clerk the day I was locked out, the moment I was locked out.
So
I did that.
we moved past that getting locked
No,
out
that
on
was my
March
trial date.
18th. Yeah, so I'm
How
giving
soon
you
can I get
another.
another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
I love how he is basically saying he is not dealing with this anymore. Maybe if the people of the state of Michigan tell him how ridiculous he sounds, he will finally understand.
July 23rd, 2024 at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you
all
protecting
parties-
your interest. You protecting your interest, and you're gonna dismiss it on that date. So you trying to play with me? You could dismiss it
Oh
today,
my
sir.
God.
You literally, but
A final pretrial 8:30.
you are
Miss
literally
Mason.
violating my due process. You can't even give me a written excuse, but you want all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we
needs
can
it
talk in a
bad.
breakout?
Excuse me, ma'am. Excuse me, ma'am. I am in pro se.
Go to
I'm in
judicial
pro se.
tenure, go wherever you want to. Final pretrial of
I
July
am. It's all good.
22nd.
I
And the
am.
trial date is going to be July 23rd. All the parties must appear on the final pretrial date. And the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very good day, Mr. Green. Best of luck to you.
That's not my name.
Yeah, Judge, get it right. His name is Dumb McDickflute'll be. And you know Judge Perkins had to throw in one more jab before he left.